Hello, everyone. Welcome to the Fulgham Law Firm. I'm Jeff Hampton, an attorney here with the Fulgham Law Firm, and I want to talk to you today about this subject. Can an alleged victim drop a domestic violence case? Maybe you're facing assault charges, maybe domestic violence charges that are against you currently. What if the alleged victim is now saying, look, I regret what was said on this, and some of what was said to the police I don't feel was accurate. What can they do? Can they drop the charges? Is there something under the law that allows them to be able to do that? We're going to talk about that. I'm going to go over the ins and outs of what an alleged victim can potentially do to affect a domestic violence case. And if you'll wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Domestic Violence Case in Texas. Okay? Now, let's just jump right into this for a second. Imagine, in the heat of the moment, let's look, this is human nature. In the heat of the moment, sometimes we all say things that we regret. How many times have you had something come up in your life where you get upset about something and you said something and later on you look back and you go, you know what, I really wish I wouldn't have said it that way, and I don't think I was being fair when I said that. Well, what if that scenario takes place, but those words are shared with a police officer? What if that's given to a police officer and the officer then writes all this stuff down and now someone goes to jail as a result of that? This scenario has played out many, many, many times at the Fulgham Law Firm. And what we want to do is talk about how serious this is, because if the original statements given in a domestic violence case were not accurate or they need to be expounded upon, that can have a dramatic, profound effect on someone's future if they're wrongfully convicted of a domestic violence case, okay? Now, here's the thing. People ask me very generally all the time, hey, listen, if a alleged victim on a domestic violence case just makes a phone call up to the DA's office and just tells them they want to drop the case, won't they drop the case? No, they won't. Very important to know this. Almost every district attorney's office in the state of Texas, certainly in the North Texas area, has a no-drop policy, a zero-tolerance policy related to domestic violence cases, which means even if the alleged victim wants to drop the case, they're not going to do it, okay? And they'll tell them that. In fact, many times, every attorney in our office here at the Fulgham Law Firm is a former prosecutor. We've all been trained up at the district attorney's offices and understand how they're instructed to handle these types of cases. And listen, I understand the philosophy behind it. The philosophy is it's important that when you talk about a large percentage of domestic violence cases, people will want to decide they want to drop the case. Well, they feel like, maybe this person's being put under duress. Maybe there's battered woman syndrome, battered spouse syndrome. There's these things that exist out there that we're not going to just drop it just because you want us to. Well, that makes sense, but I want you to understand, what about the situation where an alleged victim comes up and says, look, I was super emotional that night. I need to make sure I clear the air on this and that justice is really done and that someone's not treated unfairly. What can happen? Well, first, before we get to what you can do, I want you to understand, don't be too discouraged just because an alleged victim cannot just make a phone call and dismiss the case. Let's focus on what you can do. Let's talk for a few moments about why the district attorney's office will not dismiss a domestic violence case automatically. Domestic violence is a crime in the state of Texas. And when someone is accused of domestic violence, the issue is taken up by the state rather than the actual alleged victim themselves. So legally, the state of Texas has an interest in prosecuting the case regardless of what the victim wants to do. And so the state will always say they don't drop charges. And I understand they want to create a safe environment for alleged victims, put them in a good spot, and make sure that they have no fear of the prosecution process and make sure that justice is done. But let me go over with you for a moment. Let's identify very quickly when an alleged victim of a domestic violence wants to do the right thing, wants to make sure and clear the name of the person who's been arrested. What can they do? Well, number one, you can always call the district attorney's office. But when you call the district attorney's office, you're going to talk to a prosecutor who's assigned to the case directly. But in doing so, you can share with them that you want to drop the charges. But I want you to understand, Just deciding you want to drop the charges is not going to be enough. You are going to have to share information with that prosecutor to make it clear what actually took place. You're going to have to articulate that information to the prosecutor. Okay, so a simple request to please drop the charges will not get it done. But it is important that you tell the prosecutor what happened if that's the approach you're going to take. That's number one. Number two, you can do what's called an affidavit of non-prosecution. Now, I have people call me about this all the time, and they say, well, listen, the affidavit of non-prosecution, I've talked to all these other attorneys, it's not going to make a difference. They're not going to drop the case. That's true only if the affidavit of non-prosecution is going to say, I don't want to cooperate, drop the charges, leave me alone, right? But if you find out that the alleged victim, if there's an alleged victim standing there saying, I don't feel like it happened this way. I need to make this clear. I want to make sure that this is handled the right way, and I need to articulate some things, and I want it down on a piece of paper so it's not twisted or turned into something else. An affidavit of non-prosecution can be very powerful. And the reason why is because the clear facts of what actually took place can be put down on that statement, on the actual affidavit. It can be notarized, and now that affidavit becomes a piece of evidence as valuable in the case as the police reports or a video or anything else. Because now an actual explanation of what took place that it can be used for evidentiary purposes will be submitted to the prosecutor. And I want to remind you of something. Every case, including domestic violence cases, must be proven beyond a reasonable doubt by the government, not by you. So when an alleged victim wants to come forward and make sure and do the right thing and give the information about what actually took place, it makes that much more difficult for the state of Texas to prove the case, okay? So that's number two. Number three, you can decide you don't feel comfortable with giving a statement. The alleged victim can decide not to give a statement or to not call the prosecutor, but instead to show up to trial and give testimony about what actually took place, okay? That's always an option. And obviously any good criminal defense lawyer can walk you through all of these options. But I think it's very important that you understand what recourse you have, because listen, if there's somebody who's claiming to be a victim, the state of Texas does not provide them this information. That is not something that's provided to them as far as where they stand. They don't ever talk to an alleged victim about what to do if the information is not accurate and it needs to be corrected. So my point is, listen, stay calm. Anyone charged with this type of situation is innocent until proven guilty. And if you or a loved one are facing a domestic violence charge and you're aware of the fact that there's an alleged victim that has come forward and says, this is wrong, and I want to drop this charge, and I don't feel the original police reports are fair and accurate, and I need to clear the air, then call the Fulgham law firm, and we will give you a free consultation, walk you through these options, and you can make sure that you're given a fair shake in this situation so that justice will prevail and you're not wrongfully convicted. So if you have any questions, don't hesitate to contact us at the Fulgham law firm at 817-877-3030. And I promised you if you waited around to the end of this video, I'd give you a free ebook, What to Do If You've Been Charged with a Domestic Violence Crime in Texas. Click the link below. We'll be happy to send it over to you. And thanks for joining us on our YouTube channel today. And I look forward to seeing you on our next video series.